Hey, one of my clients did everything Reddit tells you to do. Multiple rentals, big umbrella policy. They felt really safe. Then a plaintiff's attorney pulled the insurance declaration page and stopped negotiating with them. Why? Because insurance doesn't end lawsuits. It actually starts them. What ended this case wasn't more coverage. It was when the attorney realized there was nothing left to take. And today what I'm going to be doing is I'm going to be showing you how smart investors make their real estate look worthless. And I'm talking about legally, using an equity stripping strategy that we refer to as friendly liens. Listen, insurance works and is great for small claims like slips and falls and minor injuries, nuisance lawsuits, all that type of stuff. But once your case crosses a certain dollar threshold, listen, insurance stops being protection and it actually starts being an advertisement for attorneys. Why? Because insurance doesn't end lawsuit. It defines the opening bid. And that's something so many people miss when it comes to asset protection for their real estate. Hey guys, I actually used to work for one of those insurance type law firms. Here's what they do. They ask how much insurance is there and what's behind it. Yeah, we would do an asset search. Once they know your coverage limits, they immediately look past them. That's that asset search. And what do they look to next? Assets and equity. See, these are things that can actually be taken. Insurance is just the first layer of discovery. It's not the end of the conversation. And that's what so many real estate investors get wrong. They don't understand the insurance is the beginning salvo. You see, here's the most dangerous sentence in real estate investing. As long as you have enough insurance, you're fine. I hear this everywhere. That advice, it's completely broken. And it keeps getting repeated, unfortunately, on different forums and from different events that I attend. People come up to me and they say, hey, my attorney told me this, or I read this on Reddit. Listen, do not follow that advice. Even if other investors are repeating this mistake and they feel confident about it, it's just flat out wrong. Insurance doesn't make you lawsuit proof. It makes you worth suing. Think about it for a minute here, right? From the attorney's side, if you have a lot of insurance, great. They want to go after you for that because most of those attorneys are on a contingency fee basis. They don't get paid unless they collect. So every case starts with the basic question. Is the defendant collectible? And insurance answers that initial question immediately. But the moment the attorney sees, hey, there's more there than just the policy, the gloves are coming off. At that point, the lawsuit is no longer about compensation. It's about how much money can I extract from the other side. Listen, how do you want the plaintiff's attorney to evaluate you? Well, I'm going to walk you through the actual checklist of what attorneys use. And this isn't theory. No, this isn't speculation. This is how cases are actually screened. Okay, so step one, here's what they do. They look at your insurance declaration page, and that tells them policy limits, umbrella coverage, and how aggressive to be. Now, after they look at that, step two is, hey, let's perform a title search. If we're assuming John, then I want to know what John has. And this is where things get serious because they're looking for your assets. If they find you have property, then they want to know how much equity you have in the property and how many liens are against those properties because, again, that's going to determine what their recovery is going to be. You know, people that have clean property that's all paid off, well, those are going to look much more attractive than somebody that doesn't have a paid off property. Now, step three is a cost benefit decision, right? This all comes down to money for attorneys. How much time do they want to spend pursuing a plaintiff? Pursuing a defendant? Because at the end of the day, it depends on how much can I collect. Listen, if I don't think I can collect much against you, then I'm definitely going to take the insurance. And this is something as a real estate investor, you should start thinking about this because I run into people that have a lot of assets they start building up and they feel really good about the equity in their property. They say, hey, look how much it's run up in the last 5 years. Well, you know what? That is also your biggest risk. Because if the answer to the attorney's question is, hey, they've got plenty of equity here, maybe they even have a clean title, then the case is going to escalate and they're going to push harder to go after you. And depositions get nasty and definitely the settlement demand's going to jump. So time becomes a weapon, and that is why two identical injuries can lead to wildly different outcomes. And it's not because of facts, but it tends to be because of the balance sheet of the defendant. Now, here's what I want to talk about. Okay, I want to talk about why equity is more dangerous than no insurance. And here's a part most investors don't want to hear. A paid off property is one of the more dangerous assets you can own. No, it's not because it's a risky asset, it's because it's easy to take. High equity means, hey, there's no bank in front of the creditor. There's no senior lien soaking up the value. It's a clear path from judgment to seizure. But ironically, what I found is that investors who played it safe and aggressively paid down their debt oftentimes create them for themselves the largest legal target. And LLCs, they don't solve this. Get this, right? You can have a limited liability company which controls all these assets, and they do nothing to reduce how attractive that asset looks to a potential creditor. If there's visible equity, then the lawsuit is going to keep going. And this is where most asset protection plans I see right now coming through are quietly failing, because LLCs, they have this false sense of security that they're going to stop the damage. I mean, they're useful, but they're not magic when it comes to asset protection planning. So they do one job, all right? They silo properties. That's it, right? To ensure that your assets don't spill over. Let me just show you now what I'm referring to. So let's assume that I have an LLC right here, and inside of this limited liability company, we've put a few properties, just like this. And then I create a secondary LLC over here, and I do the exact same thing. I adopt and I put 3 properties in each of these LLCs. So if something happens in this LLC, that liability is going to stay contained inside of that one limited liability company, right? It doesn't mean the LLC isn't going to get sued. And this is, again, what I'm talking about here is that people think if I set up LLCs, it discourages lawsuits. No, all they do is they protect you personally, right? So if I'm down here as the owner of these LLCs, I'm protected, but the LLC is going to be sued, right? And if a creditor gets a judgment against this LLC right here, then what they're going to be looking for is recovery. How much equity do we have in those 3 properties? So if there's equity sitting there, it's clean, it's easy, it's obvious to find, of course, then the lawsuit is going to proceed on an expedited basis. They realize now, hey, there's somebody here that has insurance and they have equity. And that, again, is where I see investors get confused. I read this all the time on Reddit posts, or real estate investors don't understand this basic comment, right? That they keep thinking that the LLC is somehow protecting their assets. No, what the LLC is doing, it's protecting you from the claims brought against the property. So what do we need to do here to protect the properties themselves? All right, so what we want to do is we want to make sure that there's no equity, right? We want to make sure that these properties are not worth pursuing. You see, plaintiff's attorneys, as I talked about, they're businessmen, right? They want to basically make as much money as they can for themselves and their clients. Let's get a payout. So what we need to do then is fight back against that. And the way we do that is we take and we drive your equity down. Now, one way you could do that, of course, is go to a bank and get a second lien against these properties. But the problem is they're investment properties. And sometimes it's hard to get an equity line of credit against your own property. So what I want you to do is create your own. Okay, now this doesn't mean it's fake debt. All right, we're not playing games here. It means this, is that you're intentionally placing a legitimate claim against your property. So now we're sucking up that equity. So here's how we do it. What we've been doing now is we create a Wyoming limited liability company right down here. Now, this has to be Wyoming. It cannot be an LLC set up in your state, because if you're attached to this, meaning if I looked at this LLC and I see that you're the owner, let's say this is John, and I see John's the owner of this limited liability company. For example, assume we set this up in Colorado, and then John has some Colorado LLCs over here. The strategy that I'm about to share with you is not as effective, because I can see that John is tied to everything when I do my asset search. When I look at the entities, okay, you're going to see that John owns everything. By choosing Wyoming for your limited liability company, or you could use Delaware. I prefer Wyoming, it's less expensive. You're cutting that tie. You see, in Wyoming, they don't collect, that is, Wyoming doesn't collect any information on you. So no one knows that this is your LLC. So the first thing you have to realize is that if you're going to use the strategy you're about to learn, it starts with having a Wyoming limited liability company. That is the first thing you need. Now, here's what we do. We take this Wyoming LLC and we enter in to an arrangement with our other limited liability companies. Okay, that arrangement that we're going to enter into is referred to as a line of credit agreement. So we're going to do a line of credit. Now, this is very simple to put together. What it means is this. You're on both sides. You have Colorado LLC and you have Wyoming Limited Liability Company. And what you're agreeing to do is that Colorado LLC wants to borrow from Wyoming LLC. Well, add up the equity in your properties. Let's say I have 100 here, I have 200 here, and I have another 100 here. Now, obviously, you would never want to do this, have 3 properties in one LLC, but I just want you to understand how this all plays together. So you would have a total of $400,000 equity sitting in this limited liability company now. And what I'm going to do is I'm going to make that disappear. Now, if you don't understand what I mean when I say I'm going to make it disappear, what I'm telling you is that I'm going to make it appear on a title search that each of these properties are fully encumbered, that there is no equity there available for that aggressive attorney for the reasons that I started out this video mentioning. We want to make that become an unattractive proposition for them, that they do not want to go beyond our policy limits. So we're going to put together a line of credit, which means that Colorado LLC wants to borrow from Wyoming LLC a set sum of money. They're not going to do it today. They're going to do it over time whenever they feel that they need it. And Wyoming LLC agrees to loan if they have it. So my Wyoming LLC now will enter into this agreement with the Colorado LLC. But I'm not going to do 400, okay? I am going to set this, in this case, at $600,000. I'm going to go beyond my equity. Because again, I want to make it appear that, hey, there is nothing to go after here. Stay away from these assets. They're over encumbered. So we're going to enter into this line of credit for $600,000. So let me just go back. I'm going to clean this up for you all right here. So here's my Colorado LLC. And this investor has made the mistake of putting 3 properties per LLC. And I'll draw it out with just one. It's pretty much the same here. And here's your Wyoming LLC over here. Okay, so we enter into a line of credit between these 2 entities, line of credit, and of course that has to have a promissory note, where the Colorado LLC agrees to pay back the Wyoming LLC on any monies it's borrowed up to this $600,000 limit with interest. That's what the promissory note covers, and that's what this line of credit covers. Now, those 2 documents are private. They are not recorded anywhere, so no one sees this. It's in the background. Now, what the Wyoming LLC is going to do, it is going to record a secured interest against these properties. So here's where the magic happens. Let's take property number 1 right here. Okay, assume this property right now has $200,000 equity. That's because the fair market value of the property is $500K. There's a loan on the property from a community lender for $300K. So all we're doing is we're taking the difference between the fair market value, we're taking the loan out of it, and that leaves us with our equity. I mean, if I sold the property tomorrow, that's how much I would get. 300 goes to the bank, I collect 200. Now, this is important because by putting this line of credit in place, what this Wyoming LLC is going to do, or essentially what you're going to do, is you're going to take the full value of this, the $600,000, and you're going to record a deed of trust. I'm going to put I should just write it down here, deed of trust or mortgage. And that depends on the state in which you reside in, okay? Because some are mortgage states, some are deed of trust states. In fact, I will provide that in the show notes for you that lists the difference between the 2 states so you know which document you need to record against the property. So you're going to record either a deed of trust or a mortgage against this property right here. And what that's going to do in this case is be a second position. So you'll now have a recorded deed of trust, secondary deed of trust for $600,000 against this property. So now that property shows that it's underwater by $400,000. That's what it'll do. Now, if somebody's looking at this, they're going to think, wow, you gave that asset as collateral for a jumbo loan, and now a lender's sitting there and they've sucked all the equity out of this. All the air is taken out of the room. And that's exactly what we want them to think. So what it does now is it pushes those attorneys off to the policy itself and leaves our equity protected. So now we've got this equity here fully encumbered, over encumbered. Now, some of the questions that typically come up when I talk about this strategy is they say, well, Clint, I don't have $600,000 in this Wyoming LLC to do the strategy. You don't need $600,000 in this Wyoming LLC because you're not loaning the money, all right? This is a smoke screen. So then when I explain it that way, sometimes people will say, well, Clint, that's fraud. Is it? Why is it fraud? Because you're agreeing to loan yourself money and you're securing the interest. Maybe if you never loan the money, that doesn't mean it's protected from a creditor. I mean, if a creditor moved forwards and they tried to go after the property, even though it looks fully encumbered, they would eventually figure this out and you couldn't claim your Wyoming LLC is owed $600K if you never loan the money. Hey, I'm just putting it out there. If the attorney wants to be lazy and just settle for the policy limits, that's on them. That's not on me. This is what it does. And I have another way of explaining it to people before where they've, again, had trouble grasping this. I say, if you go into your local bank to get a home equity line of credit on your personal residence, let's say they gave you a home equity line, here's my house, and they say, Clint, you qualify for a $300,000 home equity line. Great. So they give you a checkbook. They don't give you cash, they give you a checkbook. And in exchange for that home equity line, they file a deed of trust or a mortgage on your house for $300K. Now, when they do that, if you never borrow the money, is that fraudulent? No. If you never borrow the money and you go to sell the property, does that bank get $300,000? No, because you never borrowed the money. So this is how the strategy works. It's designed to sit on there to make it appear to creditors that are coming after you that, hey, the policy limits or the insurance policy is where you want to focus on. You don't want to go after anything else because there's nothing there to collect against. This is what smart investors do when it comes to protecting their real estate. They use this one strategy right here, especially when your properties start to go up in value. Now, I want to show you something else. So here's something really cool. So let's assume that you have, you're doing it the right way, which is I always advocate having one LLC set up for each property. Now, so if you've done it the right way and you weren't in the situation that I just described, because that was actually a situation that I read on Reddit, and it was the basis for this video. So let's assume that you're here and you have your Wyoming LLC down here. Now, this Wyoming LLC is typically will be your cash LLC where you keep your savings account should be in there. Your brokerage account would be held inside of this LLC. So let's assume that this property over here, this is my Colorado LLC. Again, this is LLC number 1. This property is paid off. And I know a lot of landlords who really strive to pay off their properties. They want to get rid of all debt. All right, I'm one of those. But then when I do that, I also realize that's a problem because when I have no debt on my property, I have a lot of equity there. So how do I confront that? I use my Wyoming LLC here to record a deed of trust against this property. So if the property has a value of $500,000 of equity, then I will put a deed of trust on there for $600K, meaning I'll put that promissory note and the line of credit agreement together for $600,000. Okay, now, if I thought I was going to get sued, what I would do with the money over here, let's say I had $250,000 sitting in this account. Now pay attention to this strategy because this strategy is money for you. It's going to protect you. So let's say that, a creditor, they see this and they still want to go after me because they figure I'm going to get a judgment. We'll just slap that judgment on that property. Okay, so if this happens, I'm going to actually borrow the money. My Colorado LLC, I say, you know what? I want to borrow $200,000. So I'll move $200,000 from here into here, and then I'm going to take that money back out as a distribution. Okay, so what you're doing here, if you think you've got an issue coming up with the property, you're securing it now for $200,000. So you actually loan the $200,000 and you can pull it right back out. Oh, by the way, non-taxable here. There's no tax consequences to doing this, right? So you put the money in, pull it back out, and you can actually put it right back into this LLC. It's not a problem. But now you've actually used 200 of that 600K. So this is where it gets really interesting. So now you got 200K here. So let's assume this guy right here, he's not deterred. He took your policy limits, but he still wants more, and he's going to slap this lien on that property. So he puts a lien against a property, let's assume for $100,000. If you want, the way you make that lien disappear is you can have your Wyoming LLC foreclose on your own property because you're a first position lien holder. And if you foreclose on your own property, you'll wipe this guy out. So there's a benefit to you as well by having this in place. It gives you options. The friendly lien solves the issue that a lot of real estate investors have as they start having a lot of equity growth in their real estate, and then they see that as a potential target to plaintiff's attorneys. So we want to make sure that we're putting this together right. So I went through a couple of things here. You have to have a line of credit. You have to have a promissory note. You have to file a deed of trust. Okay, and if you do borrow the money, you got to pay back at least the interest on that if you want a court to respect this. If you don't follow the right procedures here, then that can be a problem for you. So think about it this way. If you've got high equity properties and you're relying on insurance alone, you don't have protection. Essentially what you have is exposure. So what smart investors are doing is they're not sitting around waiting for lawsuits to test their plan. They structure it so a lawsuit never makes financial sense to an attorney. That's how your equity gets protected. And that's how cases die early. And that's actually how real estate asset protection actually works in the real world. All right, guys, hey, if you like this video, hey, hit the like button. And if you want to learn more about this type of strategy and more, we teach a one-day tax and asset protection workshop on Saturdays. I'd love to see you there at that event. Not only are you going to learn this type of strategy and actually more, but you also have the opportunities to get your questions answered because we bring a team of attorneys on and tax professionals that are there just banging out questions to make sure that your individualized situations are being addressed. If you want to attend that event for free, go into the show notes. I got a link right there for our tax and asset protection workshop, and I hope to see you there.